Hello everyone, Namaste and welcome to the rapid revision of the business laws chapter number 1 Indian regulatory framework. I hope you guys are doing good and keeping your preparations intact. Chapter number 1, the Indian regulatory framework, has a weightage of 6 marks in the examination. Yes, you heard me right, 6 marks but only 4 pages. 4 pages, 6 marks. So let's start. What is law? So law is a set of obligations and duties, that is OD, obligations and duties, which are imposed by whom? Imposed by the government. For what purpose? For securing the welfare to the people and for providing what? Justice to the society. So these are the two objects of law, that is to secure the welfare and to provide the justice to the society. So what is law? Law is a set of obligations and duties, ODs, imposed by whom? Government. For what? Securing the welfare and providing the justice to the society. And our India's legal framework reflect the social, political, economic and cultural aspects of our diversified countries. So all the laws reflect our social, political, economic and cultural aspects of our diversified country, and you can find the same words in the even the preamble of the Constitution of India. Clear? So what is law? Set of obligations and duties which are imposed by whom? Government, for securing what? Welfare and providing what? Justice to the society. So next concept, sources of law. One of the important concept based on which they can ask questions in the upcoming examination. Sources of law. The main sources of law in India is what? The Constitution of India. Important. The main sources of laws in India is what? The Constitution of India, which is the supreme law in India, the law of the land. And we also have the statutes, or which is also called as the laws made by the parliament and state assemblies. So we have the statutes, nothing but the laws made by the parliament and state assemblies, and we also have the precedents, that is the judgment of the superior court, which becomes a rule of law to be followed by the lower courts. Then are judicial decisions. Precedents are also called as what? Judicial decisions. Then we also have the established customs and usages. So these are the three sources of what? Sources of the law. What is the first one? Constitution of India. Second one, statutes are the laws made by the parliament and state assemblies. Third one, precedents are the judicial decisions, and the fourth one is the established customs and usages. So let us discuss one by one. What is the first one? The Constitution of India, the supreme law of India. So the Government of India Act 1935, important, the Government of India Act 1935, which was passed by the what? Parliament of United Kingdom, UK, is the precursor, means this is the basis of our Constitution of India. Most of the provisions of the Constitution of India are based on what? The Government of India Act 1935. So the Government of India Act 1935 defined the characteristics of what? Of the Government of India, from unitary to what? To the federal. So the best example for unitary system of constitution is the UK system of constitutions, where Queen is the or the monarch is the superior authority, and the best example of federal government is the US constitutions or US political system. So it defined the characteristics of the government as what? As a federal. Powers were distributed between the center and state. So under the Government of India Act, the powers were distributed between whom? Between the center and the state to avoid any disputes. In 1937, Federal Court was established. Now it is called as Supreme Court. The Federal Court. Now it is called as what? Supreme Court of India. So in 1937, Government of India Act was made in which year? 1935. Passed by which parliament? United Kingdom. It is a precursor to the what? Constitution of India. It defined the characteristics of our government, that is federal. It also distributed the powers between center and state to avoid what? Disputes. And in 1937, that is after 2 years, the federal court was established, and it had a jurisdiction of what? Appellate, original as well as advisory. Now what is appellate jurisdiction, sir? To hear the appeals from the lower courts. Cases. Second one, original jurisdiction, where the court can try the cases originally, that is writ jurisdiction is also there. Next one, advisory, the Supreme Court can advise the president and the government in case of certain matters. So these were the powers, are the powers given to whom? Given to the federal court under the Government of India Act 1935. The federal court was supplanted by the India's current apex court. That is Supreme Court of India. That is, it is replaced by the Supreme Court of India. So now we have the Supreme Court of India. The Constitution of India, which came into force in which year? 1950. First 26th of January and 1950 is the foremost law that deals with what? The framework. It provides the political framework within which our democratic system works, and our laws are made for the people, by the people. That is nothing but democracy. Democratic system. What is democracy? Demo means people, cracy means power, so it is a people's powers. Next one, the constitution also provides for and protects certain fundamental rights. Important. So part 3 of the Constitution of India provides what? The fundamental rights to the citizens. It also provides what? Fundamental duties. It also provides the fundamental duties as well as the powers and duties of whom? The governments, both central as well as the states. So the Constitution of India provides what? Fundamental rights, fundamental duties, as well as the powers and duties of the government, both central as well as the state. The laws in India are interconnected with each other, forming a hybrid legal system. So the laws are interconnected. No law can supersede the Constitution of India. All the laws made in India should be in conformity with what? The Constitution of India. The lawmaking power is distributed between whom? Between the center as well as the state, under the union list, state list, and the concurrent list. And the matters which are specified in the central list, who can make the laws? Parliament can make the laws. And the matters which are specified in the state list, who can make the laws? State can make the laws. State legislatures can make the laws. And the matters which are specified in the concurrent list, who can make the laws? Both center as well as the state can make the laws. Example, income tax come under what? Central list. So who can make the laws? Parliament can make the laws. Stamp duty come under which list? State list. So who collect the stamp duty? State collect the stamp duty. So this is the first sources of our Indian legal system or the law. That is the Constitution of India. Second sources of laws is the laws made by the parliament and state. The parliament and the states can make the laws by passing a bill, and the bill should be secure the assent of the president as well to become an act. It is also called as statutes. Next one, judicial decisions of the court. The judgment given by the superior court becomes a rule of law to be followed by which court? The lower court. It is called as judicial decisions of the court. It is also called as precedents. Also called as the precedents. This is the third source of laws in India. Next one, customs and usages. Some customs and usages, that is practices. Usages are the practices applicable in the trade. Applicable in the trade. If a usages is known to both the parties, that becomes a part of the contract to be followed by both the parties. And if there is a breach of that usages, the party can enforce the same in the court of law. So customs and usages which has the legal sanction, then they are also considered as sources of law in India. So there are four sources. What is the first one? The Constitution of India, important one. Second one, the laws made by the parliament and the state, which are also called as statutes. Third one is what? Judicial decisions or precedents. And the fourth one is what? Customs and usages. Next concept, process of making the laws. So the how the laws are made in India. First step, when the law is proposed in the parliament, it is called as a bill. So you should write, when a law is proposed in a parliament, it is called as a bill. And after discussions and debate, in the lower house, that is Lok Sabha, the bill is passed by voting by the members present in the house. First step is, law is proposed in the parliament, it is called as bill. Once it is proposed, there will be a discussions and a debate. Then the law is passed with the required majority of the vote in the Lok Sabha, that is lower house. So once it is passed in the Lok Sabha, the bill goes to where? Goes to the Rajya Sabha. Again, what happens in Rajya Sabha? There will be discussions and debate, and the bill is passed. So once it is passed in Rajya Sabha, that is upper house, it goes to whom? To the president for his assent. It has to obtain the assent of the president of India. So once it obtains the assent of the president of India, it becomes an act. Finally, the fifth step is the law should be notified by whom? Government. In what? In the publications called as what? Official Gazette of India. And the law will become applicable from the date mentioned in the notification as the effective date. That is the date specified by the government in the official gazette. And once it is notified, It is applicable to the people of India. So these are the seven steps involved in the making of law. What is the first one? The law proposed in the parliament is called as what? Bill. And after discussions and debate, what happens? Law is passed in Lok Sabha, it goes to Rajya Sabha. Thereafter it has to be passed in where? Rajya Sabha. Once it is passed in Rajya Sabha, it has to obtain the assent of whom? President of India. Then it has to be notified by the government in the publication called as what? Official Gazette of India. Then the law will become applicable from the date mentioned in the notification. And once it is notified and effective, it is called as an act of the parliament. So these are the procedures or formalities involved in making the laws in India. Next one, types of law. One more important concept based on which we can expect the questions in the examinations. Types of laws in India. First one, criminal law. Name itself indicates criminal laws. Criminal laws are concerned with the pertaining to the violation of the rule of law. So, criminal laws are concerned with the laws which pertain to the violation of the rule of law or the public wrong, not the civil wrong. It is what? A public wrong and the punishment of the same. So, the criminal law is concerned with the violation of the rule of law or a public wrong and the punishment of the same. Next one, criminal law is governed under the Indian Penal Code 1860 and the Code of Criminal Procedure, that is 1973 CRPC. Now the names of these laws have been changed, but we still follow this old name itself because the same thing is there in the material as well. Next one, IPC 1860. The Indian Penal Code 1860 mainly deals with what? It defines the crime and also its nature and the punishment for the same. IPC provides the definition of crimes, its nature, and as well as the punishment. For example, murder, rape, theft, fraud, cheating, and assault, criminal assault. And we have the CRPC, that is Criminal Procedure Code, which provides the procedural matters, means how to file a complaint, how the evidences are produced before the magistrate for the purpose of proving the criminal offense. So it provides the exhaustive procedure. What procedure? An exhaustive procedure for executing the punishment of the crimes. IPC defines the crimes and also provides the punishment. CRPC provides the procedure for executing the punishment of the crime. This is the first law. What is the first type of law? Criminal law. Criminal law is concerned with what? It concerned with the provisions for the violation of the rule of law or a public wrong and also punishment for the same. So we have the two criminal laws. Mainly we have two criminal laws. One is IPC, another one is CRPC. IPC deals with what? It defines the crime, its nature and punishment. Whereas CRPC provides what? The procedural aspect, like how the complaint is filed, what are the evidences to produce before the court, and what are the how the person is punished as per the laws. So all those things are given under what? Under the CRPC, that is, which provides the exhaustive procedure for executing the punishment of the crimes. Next, we have the civil laws. What laws? Civil laws. So it is concerned with the matters of dispute between whom? Individuals or organizations. Unlike criminal wrong, which are the public wrongs, these are the wrongs between the individuals. It's a violation of individual rights. So means it concerned with the matters of dispute between the individuals or organizations are dealt with under the civil laws. Civil code, the codes which deals with the civil wrongs are called as what? Civil codes. Civil code enforce the violation of certain rights and obligation to the institution of what suit? A civil suit. Civil codes enforce the violation of certain rights and obligation through the filing of what suit? Civil suit. Civil law primarily focus. What is the focus of civil laws? Dispute resolution rather than punishment. One more difference between criminal law and civil law. They may ask this question in the examination. Difference between criminal law and civil law. Criminal wrong concerned with the public wrongs, whereas civil law is concerned with what? Rights of an individuals. Next one, civil laws, the act of a process and the administration of civil laws are governed by what? Code of civil procedures. Means the procedural aspect with respect to how to file a suit and how what are the remedies can be claimed in the court of law. All those procedural aspects are given under what? Under the CPC, Civil Procedure Code. Civil law can be further classified into what? Law of contract, family law, property law, and law of torts. Like this, we have many civil laws. Examples: breach of contract, non delivery of goods, non payment of dues to the lender, seller defamation, breach of contract, dispute between the landlord and tenant. All these are the examples of what? Civil wrongs. Nothing but the violation of civil laws. Next one, the common law. It is also called as a judge made laws. A law which is based on the judicial precedent or a case law is called as what? Called as the common laws. UK, the UK system of law is based on what? Based on the common, that is judgment of the court. In India, we have the most of the written laws, but one of the common law we have in India is the tort. So tort is mainly based on what? Based on the judicial precedents are nothing but case laws. A judgment delivered by the Supreme Court in India, judgment delivered by the Supreme Court is binding on what? Binding on all the lower courts in India. As per which article? Article 141 of the Indian Constitutions. I repeat, judgments delivered by the Supreme Court will be binding upon the courts within the territory of India under Article 141 of the Constitution of India. Which article? Article 141. The doctrine of stare decisis, important. The doctrine of stare decisis is the principle supporting the common law. Principle supporting which law? Common law. So what is doctrine of stare decisis? It means to stand by that which is already decided. Means to not to unsettle the things which are already established. So the lower court should stand by the things which are already decided. Means the like cases should be decided how? Alike. The doctrine of stare decisis reinforces the obligation of the courts, obligation of whom? Courts, to follow the same principle or a judgment established by the previous decision. What decisions? Previous decisions. I repeat, the doctrine of stare decisis reinforces the obligations of the court. It is the obligations of the court to follow the what principle? Same principle or a judgment which was established by the previous decision while ruling a case where the facts are similar. What is similar? Facts are similar. Nothing but the like cases should be decided alike. So there are 4 points you're supposed to write in the examination if they ask about common law. First thing, it's a judicial precedent or a case law is a common law. Judicial judgment delivered by the Supreme Courts will be binding upon the courts within the territory of India under which article? 141 of the Constitution of India. The doctrine of stare decisis is the principle which supports the common law. You must write this word called as a doctrine of stare decisis is the principle supporting the common law. So what does it mean? It's a legal phrase that means to stand by the things which are already decided. And doctrine of stare decisis is the one which reinforces the obligation of the court to follow the same principle or a judgments established by the previous decisions. Clear? This is the third process of law. Fourth one, principle of natural justice. Nothing but these are the inherent principles of justice system in India. Principles of what justice? A natural justice. So we have three principles of natural justice: nemo judex in causa sua, audi altum partem, and reasoned decisions. So you should write all the three principles while you write the answers for these questions. So principle of natural justice, nothing but dharma. Natural justice, often known as just natural deals. Important, it is also known as just natural deals with certain fundamental principles of justice going beyond the written laws. Even though these principles are not mentioned in the written laws, these are part of our judicial system, our legal system. What are they? The following are the principles of natural justice. What are they? First one, nemo judex in causa sua, means what? No one should be made a judge in his own case, and it is a rule against the prejudice. Correct, right? So no one should be made a judge in his own case. If I am the one who is accused, can I judge my own case? No, that is against the natural principles of justice. So this is the first natural principle of justice. Nemo judex in causa sua. Next one is what? Audi altrum partem, means what? Hear the other side as well. So can a court decide a case without hearing the opposite party? No, no. It is against what? Principle of natural justice. Audi altum partem means what? Hear the other party or give the other party a fair hearing. The next one is what? Reasoned decisions. Can the court decide the case as arbitrarily? No, it has to be based on what? Based on the reasons. a well-founded reasons. When a court gives a judgment, it has to state the reasons for giving the deciding the case in a particular manners. So reasoned decisions are the rules of what justice and natural justice. I repeat, so these are the three principles of natural justice. What is the first one? Nemo judex in causa sua. Second one, audi alterum partem. Third one, a reasoned decision. What decisions? A reasoned decisions. So these are the four sources of what are types of law. What is the first one? Criminal law. Second one, a civil law. Third one, a common law. Fourth one, principles of what justice and natural justice. Next one, enforcing the law. For enforcement of the law, it is the duty of whom? Duty of the executive. So enforcing the law is the job of whom? Job of the executives. Depending upon whether the law is a central or the state law. Then if it is a central law, who has the obligation? Central government. If it is a state law, state government. They will be the enforcing authority. The government of India exercises executive authority through the number of government ministers or department of the state. The ministry is composed of employed officials known as what? Civil servants. And it is politically accountable through whom? Through a minister. Most major ministries are headed by what? Cabinet minister, means the principal minister, who sits in the Union Council of Ministers and is typically supported by a team of junior ministers who are called as ministers of state. So the enforcement of law is the job of the executive, depending upon whether it is a central law or the state law. Central government or the state government will have the obligation of enforcement of the laws, and the government exercises the executive authority through what? Number of government ministers and departments of the state. Clear? Next one, there are certain various ministries. First one is what? Ministry of Finance. Ministry of Finance. The Ministry of Finance is the ministry within the government of India concerned with the economy of India, serving as the treasury of India. Concerned with the economy of India, serving as a treasury of India. In particular, it concerns itself with what? Taxation, financial legislation, financial institutions, capital markets, center and state finances, and the union budget. One of the important functions of the finance ministry is presentation of the union budget. What budget? Union budget. We should write, the Ministry of Finance is the ministry within the government of India concerned with what? Economy of India, as well as serving as a treasury of India. In particular, it concerns itself with what? Taxation, financial legislation, financial institutions, capital market, center and state finances, and the union budget. And one of the important functions of the ministry is to what? Present the union budget. And Sri Morarji Desai, one of the ex-finance minister of India, he has presented 10 union budgets. How many union budgets? 10 union budgets. Constitution of Ministry of Finance, it is the apex controlling authority. It has four central services, namely Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, and Indian Civil Accounts Service. So these are the provision with respect to our Ministry of Finance. Next one, Ministry of Corporate Affairs, MCA, Middle Class Abbailo. No, Ministry of Corporate Affairs. It is an Indian government ministry again. It's primarily concerned with what? Administration of Companies Act 2013, Administration of Companies Act 1956. Sir, sir, how come it is Companies Act 1956, sir? With respect to producer company, what company? Producer companies. Still, we are supposed to follow what? Companies Act 1956 itself. Next one, Limited Liability Partnership Act 2008 and Insolvency and Bankruptcy Code 2016. So the Ministry of Corporate Affairs is concerned with the administration of what? Companies Act 2013, Companies Act 1956, and LLP Act 2008, and Insolvency Bankruptcy Code 2016. It is responsible mainly for the regulation of Indian enterprises in the industrial and service sector. So, regulation of Indian enterprises. The ministry is mostly run by whom? Civil servants of ICLS cadre. These officers are elected through what? Civil service examinations. So clear? So Ministry of Corporate Affairs is the what? Indian government ministry concerned with what? Administration of these act, and it is responsible mainly for regulation of Indian enterprises. Next ministry is the Ministry of Home Affairs, which is also called as Griha Mantralaya. It is a Ministry of Government of India. So it is also a Ministry of Government of India. It is the Interior Ministry of India, and it is mainly responsible for what? Maintenance of internal security and domestic policy. So it is a Ministry of the Government of India and responsible for the maintenance of internal security and domestic policy. The ministry, the Home Ministry, is the headed by what? Union Minister of Home Affairs. The present Union Minister of Home Affairs is Amit Shah. Next ministry is MLJ. One of the important ministries, Ministry of Law and Justice. In Government of India, it is the Cabinet Ministry. So it also, this ministry forms a part of the Cabinet of the Government of India. It deals with management of legal affairs. First one, it deals with management of legal affairs. Second one, it also deals with legislative activities. And the third one, the administration of justice. I repeat, the Ministry of Law and Justice in India, it deals with three activities. First one is what? Management of legal affairs to the legislative department. Second one, legislative activities to the Department of Legal Affairs. And the third one, administration of justice to the Department of Justice. The Department of Legal Affairs is concerned with what? Advising the various ministers of the central government. So the Department of the Legal Affairs is concerned with advising the various ministers of the central government, while the Legislative Department is concerned with what? Drafting up principal legislation for the central government. This is the work of whom? The Ministry of Law and Justice. Next we have SEBI, a regulatory body to regulate what? Securities and commodity market in India. And this was established under the SEBI Act 1992. Next one more important regulatory body is the RBI, Reserve Bank of India. So India's central bank, RBI is what? India's central bank, and it is a regulatory body responsible for what? Regulation of Indian banking system. What system? Indian banking system. I repeat, it is a India's central bank and it's a regulatory body responsible for the regulation of Indian banking system. It is responsible, it is under the ownership of what? Ministry of Finance. It also comes under the Ministry of Finance, that is Government of India. It is responsible for the control, issue and maintaining and supply of what? Indian rupee. So it is responsible for the control, issue as well as maintaining the supply of Indian rupee. It also manages the country's main payment system. What system? The main payment system, and works to promote the economic development. What development? Economic development. RBI has established what? NPCI, National Payment Corporation of India, which is a specialized division to regulate the payment and settlement systems in India. So the Deposit Insurance and Credit Guarantee Corporation, this is one more important, DICGC, that is Deposit Insurance and Credit Guarantee Corporation, which provides an assurance to the extent of 5 lakh rupees for the amount deposited in the banks. So even if the bank becomes bankrupt, the DGCI will provide an insurance up to how much? 5 lakh rupees. Next one, IBBI. What is IBBI? Insolvency and Bankruptcy Board of India. So it is the regulator. It is the regulator for overseeing what? Insolvency proceedings. And entities like insolvency professional agencies, insolvency professionals, and also information utilities in India. It covers the individuals, companies, limited liability, partnership, as well as the partnership firm. So the IBBI covers the insolvency of individuals, companies, limited liability, partnership, as well as the partnership firm. The new code will set up the resolution process. It will speed up the resolution process for the stress assets in the country. To revive the stress assets in the country, it will speed up the insolvency process. It attempts to simplify the process of insolvency and bankruptcy proceedings. It handles the cases using the two tribunals. One is NCLT, another one is Debt Recovery Tribunals. So these are the provisions with respect to IBBI, that is Indian Insolvency and Bankruptcy Board of India. Next, we have structure of Indian judicial system. One more important concept based on which we can expect 6 marks questions in the upcoming examinations. So let's discuss. So when there is a dispute between the citizens and the government, the disputes are resolved. Disputes are resolved by whom? By the judiciary. So whenever there is a dispute between the citizens or between the citizens and the government, the disputes are resolved by whom? By the judiciary. Functions of judiciary. The functions of judiciary system of India are what? Regulation of the interpretation of acts and codes. So judiciary takes care of what? Interpretation of the acts as well as the codes. So what is the difference between the acts and codes? Codes are the combination of different subject matters. For example, we have IBBI, Insolvency and Bankruptcy Code of India, IBC, Insolvency and Bankruptcy Code of India, which deals with insolvency of individual as well as the body corporate. So because it deals with two different subject matter, it is called as what? Codes. So it also, the judicial system also provides the what? Dispute resolution. So solving the dispute, and also promotes what? Fairness among the citizens of the land. It promotes the fairness among the citizens of the land. So these are the functions of what? Functions of the judiciary. Next one, the hierarchy of the courts in India. So this is what the topic based on which they can ask question in the examination. Hierarchy of courts in India. So at the top level, what do we have? The Supreme Court. What do we have? Supreme Court. Supreme Court is the apex body. What body? Apex body of the judiciary. Judiciary. Earlier, under the Government of India Act 1945, it was called as what? Called as the Federal Court. But now it is called as what? Apex body of the judiciary. It is also called as Supreme Court of India. The Chief Justice of India is the highest authority, who is appointed under the Article 126 of the Constitution of India. The principal bench of the Supreme Court, the principal bench of the Supreme Court consists of how many judges? As 7 judges. But in total, in the Supreme Court, there are 34 judges, including what? The Chief Justice of India. I repeat, Supreme Court is the apex body of the judiciary. The Chief Justice of India is the highest authority, appointed under Article 126 of the Constitution of India. The principal bench of the Supreme Court consists of how many judges? 7 judges. A Supreme Court consists of how many judges? 34 judges, including what? Chief Justice of India. And an individual can seek the relief in the Supreme Court by filing what? A writ petition. What petition? A writ petition. Under which article? Article 32 of the Constitution of India. Then we have High Court. High Court, highest court of appeal in the each state and the union territory. So High Court is the highest court of appeal in the each state as well as the union territory. Article 214 of the Indian Constitution states that there must be a High Court in each state. So Article 214 of the Indian Constitution states that there must be what? High Court in each state. The High Court has an appellant, original as well as the supervisory jurisdiction. It has an appellate jurisdiction which hears the appeal from the appeal against the lower court orders. Next one, it has original jurisdictions. The persons can prefer a writ petitions or directly file a case in the High Court in certain matters. And supervisory jurisdiction. High Court exercises the jurisdiction over the district court as well as the magistrate courts. In India, there are 25 High Courts. How many High Courts? 25 High Courts. How many Supreme Court? Only one Supreme Court. An individual can seek remedies against the violation of fundamental right under Article 226 in the High Court. In Supreme Court under Article 32. In High Court under Article 226. And Calcutta High Court is the one of the oldest High Court in India. Next one, we have the District Court. District courts are the courts which are below the High Courts. Are called as what? Called as the district courts. The court of district judge deals with what? Civil law matters. I repeat, the court of district judge deals with what matters? Civil law matters, that is contractual disputes and claim for damages, etc. But the court of sessions deal with what? Deals with the criminal matters. What matters? Criminal matters. So district court, the district judge deals with what? Civil matters, whereas the court of session deals with what? Criminal matters. Under the pecuniary jurisdiction, that is based on the monetary value of the case, a civil judge can try a suit valuing not more than how much? Rupees 2 crores. But in case of High Court and Supreme Court, they don't have any pecuniary limit on the jurisdictions. But the civil judge has a pecuniary jurisdiction of up to how much? 2 crore rupees. If the case is more than 2 crore rupees, that should be referred to whom? Referred to the High Court. Next one, cases are decided based on the what? Based on the local limits. What limits? Local limit within which the parties reside or the property under dispute is situated. That is where the cause of action arises. So district court, The Court of District Judge deals with the civil matters. Session Court deals with the criminal matters. Under pecuniary jurisdiction, the civil judge can try suits up to how much? 2 crore rupees, and the cases are decided based on the what? Based on the local limits within which the parties reside and the property is situated. And the last one is Metropolitan Court. So metropolitan courts are established in the metro cities or metropolitan cities in consultation with whom? With the High Court, where the population is 10 lakh or more. So Bangalore is a metropolitan city. That is why we have the Metropolitan Court. So in the Metropolitan Court, there will be a Chief Metropolitan Magistrate who has the powers of Chief Judicial Magistrate. You will find the Judicial Magistrate in the normal district. So Chief Metropolitan Magistrate has the same powers as what? As the Chief Judicial Magistrate. And the Metropolitan Magistrate has the power of what? The power as the magistrate of which class? The first class. And this is the hierarchy of what? This is the hierarchy of the courts in India. First one is Supreme Court. Under Supreme Court we have the High Court. Under High Court we have what? District Court. Under the District Court we have the Metropolitan Courts as well as the Judicial Magistrates and Executive Magistrate. So this is the hierarchy of what? Hierarchy of courts in India. So with these we are done with chapter number 1, Indian regulatory framework, which has a weightage of how much? 6 marks in the examinations. I hope you guys find this video helpful. See you guys in the next one. Until then, keep learning law.